I can't believe I just did that. I'm just talking away at you without the mic on. Oh, my brains are mashed potatoes. I apologize in advance. Hello, Aaron. I have cobbled together the hearing, and I've cut out all the chaotic parts that are just annoying and that you can't hear anyway, okay? I want to say a big thank you to Trial TV Live. They did get back to me and they did give me permission to use their footage. So I'm really grateful for that. So the first section of this is their footage that we're using. And as usual, I'll be stopping to comment. So let's go. Oh, I should probably share my screen, huh? There we go. If I do that, somebody yell at me in the comments if I play it without actually sharing my screen. I forget to switch them over. Okay, let's go.
Mr. J, if you're able to start over and pick up, or rather than pick up where you left off, start over on the issue of, we were discussing the depositions of the recently identified experts. We had confirmed that Dr. Harper's deposition was October the 1st. Dr. Birkeland, my understanding, is no longer being called as an expert to testify, but is only being offered in some kind of advisory capacity. And all efforts to depose Dr. Brannon have not borne fruit yet. You can pick up where you've left off.
Yes, we have tried to get that coordinated and have had no success with opposing counsel. I am not even sure what this person will testify about. I don't know if it's another battered spouse syndrome expert. Florida law seems pretty clear that any other mental issues would have to be insanity. So I'm not sure exactly who this doctor is. We had prayed the court for relief and at least getting a report by today from him. We have not gotten such a report. So I don't know when we will be able to coordinate that deposition prior to trial.
Okay. Mr. Owens, with regard to Dr.
So the guy can't even come in for a deposition. I keep wanting to say the Crown. And by the way, if I say that, that's the Canadian coming out. The prosecutor doesn't have anything. He doesn't know what this doctor is even going to talk about. It's ridiculous. It's ridiculous. They're a couple of weeks from trial.
Birkeland, is Mr. J's position that that person is not going to be called at trial accurate?
That's correct.
Okay, all right. So is there any reason to worry about deposing that person at this time, Mr. J?
No, sir.
Okay. With regard to Dr. Brannon, are you still going to be offering him as a witness at trial, Mr. Owens?
Yes, Judge, and I'm going to be down there Monday night, and I'll be available all next week. I can do it at any time. The only two things I've got is the Dr. Harper's deposition on October 1 and the state's expert evaluating the defendant, Sarah Boone, on Wednesday, October 2nd.
So he's not going to call him as an expert, but he might have him at trial? Did I hear that right? What? This is it because he knows that it's crap? Is there any reason why the prosecution wouldn't have the information? Why the defense wouldn't hand over information to the prosecution? It sounds like all they have is the name. How are they supposed to check into background? You know, sometimes experts have written books, they've testified at other hearings, and so what the opposing side will do is go get the book and read the book, or go look at the records from a previous hearing. How is the state supposed to do any research? And my question is this by design on the part of the defense? I think I should have called this video Fast and Loose.
But I'm free anytime, and we can make Dr. Brannon available any day that week. I would assume we just have to get with him.
Jay?
Do you hear how he plays with words? We can get that doctor available any day. Hey, we'll give you whatever you want anytime, no problem. Look how amenable we are. And then he adds on to the end, I assume. So he doesn't know. He's playing fast and loose. He's like Sarah.
It would be helpful if I had a report so that I could craft a preparation for this person's deposition.
What is the basis to require the production of a report?
Under 3220F, you and your discretion could order it to speed these proceedings along so that I do not have to engage in a fishing expedition for an inordinate amount of time on the eve of a trial that is set to occur on October 7th, when I am unavailable on Friday next week due to an insanity placement hearing in Osceola County that has been previously scheduled and rescheduled numerous times. I am not opposed to working on Thursday, but Thursday is a court holiday, so we would have to make arrangements. And then Wednesday,
If there are other persons in the media who are appearing virtually to observe this proceeding, I need you to mute yourself, please. There's an individual by the name of Lou. Sir, I need you to mute yourself in order for the court to conduct its business. Mr. Owens.
So I cut out a whole lot there because Lou, whoever that person was, decides that, I don't know, maybe they didn't decide. Maybe they're screwy like me with tech. But man, if you don't know what you're doing, don't get into a court Zoom call and start yapping. It was really annoying. And I lost my train of thought. I forgot what I was going to say. Anyway, I think this is all ridiculous. They want everybody to twist themselves into a pretzel yet again for Sarah. Now, it's Owens asking for this, but she's the defendant. So, and you saw the motions that the state responses that I read earlier today. For every single one of those cases that they cite, when you cite a case like that, unless it's something that you cite all the time so you know the case off by heart, you got to sit and read that darn thing. And you know how long some of them can be? So you're sitting and reading and analyzing and you're researching, you're looking up stuff. It is a lot. It is a lot of work. And the defense here just keeps burying the prosecution in unnecessary work. And I think that's unfair too.
How are we going to be able to coordinate this step? Well, let me go back to you, Mr. J. 3.220F says, on a showing of materiality, the court may require such other discovery to the parties as justice may require. And is that your position that allows me to provide written reports?
yes, it is within the court's discretion to order an expert who has not produced a written report, nor have I gotten his CV to produce.
He doesn't even have his CV. Unbelievable. This defense lawyer has that expert's CV. I cannot believe that they don't. How big of a deal is it to scan it and send it over? This, I really believe, it is my opinion, okay? I got to be careful. It is my opinion that the defense attorney is doing this on purpose. Going to not only make all kinds of arguments and make the prosecution work as much as possible within the law, but just make things miserable. It's ridiculous.
A report in efforts to coordinate discovery with opposing party.
Mr. Owens, what's your response?
Judge, my response is it's a narrow issue, battered spouse. Dr. Brannon is an expert. You know, I've mentioned him 2 or 3 times. He testified in the Marcia Thompson case in Palm Beach County. That's his field of expertise.
Hold on a second. He said the doctor is an expert. didn't say in what. He testified in this other particular case, and he says that's his field of expertise. He didn't yet say that battered spouse is his field of expertise. And if that's his field of expertise and Owens is so confident, give the prosecution the blasted CV. At least give them that. Fast and loose, I'm telling you.
It's not going to be a fishing expedition in his deposition. It's going to be related to that sole issue, battered spouse. And I'm available Thursday. I realize that's a holiday, but I'm available as well.
Saying it's going to be related to that sole issue, battered spouse, is not enough information. Do you know what kind of body of knowledge is out there on battered spouse? How many areas that they could be delving into? How many unknowns to the prosecution there may be in that? There is no way to prepare for that effectively, as Sarah would say, expeditiously. And it's interesting to me that the defense demands that the prosecution have all their ducks lined in a row, which is all well and good. The prosecution should have their ducks all lined up, all their I's dotted and their T's crossed. But the defense, we'll just play fast and loose.
Well, I can make him available. I'll do everything I can to set the deposition as soon as possible.
Do we know of Dr. Brannon's availability?
I can try to get him on the phone now, Judge, if you'd like me to.
Any objection to doing that?
I don't want to burn it. If he is available on Thursday, then that will be our preference, because it's my preference to do it in person.
Fine. That will be an in-person deposition no later than Thursday of next week, the 3rd. If you are unable to have that deposition coordinated, you need to let my office know immediately, and we will set a hearing as necessary. I'm in trial next week, but I will make the time in order to make that happen.
He is living or working as listed on the witness list in South Florida. So under the rules, the deposition should have to occur there unless Mr. Owens is requesting a different location.
Mr. Owens, are you requesting a different location other than South Florida? Where's the location of Dr. Brannon?
Well, we'll ask Dr. Brannon, but if he's willing to come up here for the deposition, I'm fine with that. Or we can travel, whatever. We can do it by phone. Or
He's making a promise for this doctor. And, I saw Dr. Barry pop in there. Hello. I think that part of the reason for playing fast and loose and kind of hiding until the last minute information about the one expert is because they were stamp collecting. You remember we talked about that in the last stream? Because there is a past history there that is not good. Anyway, now he's doing the fast talking again. I mean, lawyering or salesman or politician is a perfect profession for him because he's just making this promise that I don't think he can make.
Zoom, I'm available, like I said, all week next. I'll do whatever is necessary to get the case resolved.
It's going to be an in-person deposition, so the issue is simply location, whether it's in South Florida where his office is or here.
Doesn't matter to me.
Okay, then you've got your deadline by next week, Thursday, to take that deposition. I have reviewed the state's responses to multiple matters, including the amended exhibit list and the second amended exhibit list, and a response that the state had filed regarding a second motion. Was there a second motion to suppress that was filed?
Judge, they filed a notice of objections to the state's evidence late last night. Contained within that objection to the state's evidence was basically an unfiled, legally insufficient motion to suppress statements based on a statement made to a patrol deputy prior to the first statement to the detectives in an unmarked patrol car on February 24th, 2020.
So essentially, an unfiled motion to suppress. I said it before, chip away. They're going to chip away, get a little ground here, chip away there, and try and slide things in, wiggle around, and that's what he's done. He files this thing, this objection, at like near midnight when there's a flippin' hurricane after the date that the hearing was supposed to take place. So it's after, if it weren't for the hurricane, he wouldn't have been able to file anything. So he's filing a motion to suppress, but he's disguising it as an objection to exhibits. And this is ludicrous.
Okay. I have not seen, that hasn't cleared the court file yet, I don't believe.
Judge, I believe I sent it directly to your JA. Defendant's objections to plaintiff's exhibit list.
I emailed you. Didn't you get my email?
Would have been sent to Ms. Barrios.
I have,
Last night.
Mr. Owens, the second paragraph of the second page of the objections seemingly refers to a different interrogation than what is made reference to in your motion to suppress of September 24th.
That's correct.
Okay.
May I be heard?
You filed your objections. As of right now, there's only one pending motion to suppress. Is there
That's
another
cool.
motion to suppress that's going to be filed?
I'm not sure, Judge. I had.
He's not sure if he's going to file a motion to suppress. This is after he made this objection, filed it in this ridiculous manner, disguised in this ridiculous way, and made the prosecution, you saw the response from the state. The prosecution had to scramble. I mean, it's not like they have anything else to do, any other cases in Florida. Good Lord. They had to scramble and do the research and write this thing up and respond and file it, and they're doing everything by the book. Whereas this guy, Fast and Loose, that's his new nickname, Mr. Fast and Loose. And while I emailed you, your assistant, Fast and Loose. So they did all this work, and he's like, yeah, I don't even know if I'm going to file it. File it. Withdraw it later if you change your mind. File it if that's what you're going to do. For goodness sake. I'm annoyed. Can you tell?
I had some time constraints on filing this defendant's objections to plaintiff's exhibit list. I put those last two paragraphs in page 2 on there for the purpose of preserving that issue because my client asked me to. Whether or not I'm going to file those or not is an issue that will be decided on Monday when I drive down to speak with her.
All right. It is reasonable to want to preserve the record on a thing, even though he filed it after the day that the hearing was supposed to have taken place. But okay, it's understandable. I want to preserve the record. So why didn't you just say that? Just say, I have these concerns. I'm objecting this. I want to protect the record, instead of making the prosecution have to go and do all this legal research. They're trying to bury them. They're playing games. I do not like this.
I may or may not file those, but I wanted to preserve that potential issue.
Mr. Owens, can you hear us? Cannot hear you, sir.
Can you hear me now?
Yes, sir, we can.
I'm sorry. That was my error.
What if any response do you have to, my concern is, I don't have a complete picture of what is attempting to be filed, and you're telling me you're not going to be able to know until you meet with your client on Monday as to whether or not you're going to file a motion to suppress. We're rapidly proceeding to trial in this matter.
I understand that, Judge. I had a deadline for filing these defendant's objections to plaintiff's exhibit list. Based on my last discussions with Ms. Boone, she expressed concern about those two statements that are on the second page, the last two paragraphs. I simply was preserving the right to make an objection on the two exhibits, which is the body cam of Deputy Rodriguez and the audio tape that was taken, the interrogation that was taken in the squad car by the two homicide detectives. I don't know whether I'm going to even file a motion to suppress on those two paragraphs on the second page. I plan on driving down Monday. I will see her Monday night. We'll make a decision at that time.
Do you remember the video I had? I talked about Sarah. I don't know if it was one of her letters or something about how she wanted a puppet. Ta-da! His last name is Marionette. His first name is Fast and Loose.
But I felt like I had to preserve that issue in this objection of these exhibits.
I don't know who that is.
Can't we just do the old-fashioned way? Counsel can call by phone.
Can we pull him in to, can he call over the overhead? Yeah. All right, Mr. Owens, we're going to give you a phone number to call in, sir, because there are so many people that are...
We're working as diligently as we can, I understand.
Okay. I'm going to repeat. That's when the Trial TV Live's feed stopped. And now I've got this horrible thing. So I am going to probably repeat much of what Owens said because it's very difficult to hear. And I want you to know what he's saying. Okay, so Owens is saying, well, I'm working as diligently as I can. So he's just doing the salesman talk right now.
That Ms. Boone has had the case for 4.5 years, but I have not had it for 4.5. To comply with the court's order to be ready for trial October 7th and still protect my client's rights as I see fit.
So he's just whining. Well, Boone had the case for all this time, but I haven't, and I'm trying to be ready and still protect my client's rights. And I think he's saying that partly because of his reputation and partly to get that on the record.
You're going to have till today to file that motion. You can buttress it, you can amend it, you can provide case law. The only thing I'm going to ask is that you provide...
You know what, though? He's lucky. This is a gift from the judge, but he's not getting unlimited.
The court and state attorney's office any case law that you plan on relying on, but you can always withdraw it.
Would you clarify that again, Judge?
So, first, you need case law. You can't just send stuff. You just can't send in an assertion. Wah, we don't like this. It's wrong. It's like a letter from Sarah, just in nice and better language. It violates my rights. Yeah? How? Explain it. Right? So it's a wah motion. Like it's not even real. It's an assertion. So he has to actually do some work now and do some legal research and provide the case law. And Owen says, could you clarify that for me? That he has to the end of the day. Clarify that. Do you think that he doesn't understand that? He's playing games.
Got until the end of business today or the end of the day?
So he wants to know by the end of the business day or by the end of the day, meaning like midnight, right? 11:59. He's shown a pattern of behavior already. He's just going to wiggle and wiggle and wiggle and just get a little more and just a little more. So he's going to pretend to not understand so he can kind of squeeze out a little more.
Any responses to that, Mr. J? You'll have till the end of the day, sir, no later than 11:59 tonight to file that motion if you're going to file it, because the state needs to be advised as to what, if any, positions you have with regard to those matters.
Are you referring to the motion to suppress the statements made during the body cam of Deputy Rodriguez, and then a separate motion to suppress any statements made on the audio tape of the interrogation by the two homicide detectives in the squad car? Am I correct?
Do you hear what he's doing? So he's going through unnecessarily. I mean, it's clear what the judge said. Look, if you're going to make a motion to suppress, this is your deadline. Do it. And by the way, that is a gift, because I think the judge could have said, like, forget it. Anyway, so Owens is saying, well, so the body cam, the statements made on body cam and the statements made in the car, blah, 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 blah. Well, that was what your objections were they not? So what are you doing, bud? Are you playing with words here? But the judge is not an idiot. He catches it.
I'm referring to the paragraphs that are in your objections. Second page, first paragraph, and second paragraph.
Yes, sir. I understand.
If those are filed and when those are filed, I need you to favor copies to my office, please.
Yes, sir.
Now, regarding the motion to suppress that was filed on September 24, I understand next week's very busy. I know that my office had inquired if anyone was available Friday. I now understand the specifics as to why Mr. J is unavailable on Friday. As the parties are aware, the court, this is not the court's only case. The court is in trial next week. We have a legal holiday on Thursday.
It's not the court's only case. Somebody tell Sarah that.
I don't believe that Judge Munyon has the ability to open up the courthouse just for me, as this is a statewide court holiday. That would be required of the Chief Judge of the Florida Supreme Court, I think, to make that decision. And I don't know that I have the ability to call Chief Judge Muniz to get that decision by Thursday to allow us to conduct work on that time. I will make myself available next week, but the problem is the scheduling of it, because the court is in trial, and the state certainly deserves an opportunity to understand the court's ruling prior to trial in order to prepare what, if any, rulings would be adverse or for the benefit of the defense or for the state. I don't know, because I haven't had the hearing. With regard to the 4 hours, Mr. J, why could I not review that 2-hour and 6-minute interrogation prior to the hearing, such that we would be able to save some level of judicial efficiency and economy?
Wouldn't that be good? The judge could just watch the video. I bet you the defense wouldn't like that. But the judge is asking Mr. J right now, not Owens.
I have no objection to the court doing that. I just understand that some judges in this building do not do that.
I don't have a problem looking at it in advance, and that way, if there are certain things that either yourself or Mr. Owens wants to highlight for me during the hearing, look at time step X or Y, certainly I'll give you both the opportunity to do that. But I think for judicial efficiency and economy, I don't have a problem reviewing it so that we don't have 4 hours of hearing time. Maybe we limited it to 2 for the purposes of case law argument and any testimony.
Judge, if I may.
Owens interrupting. If I may, is he going to try and take it off the rails again? The judge is going to look at the thing. Oh, and Judge Kranick knows his stuff, and he's going to bring receipts, and he knows how to distinguish things.
Yes, sir.
if I may. Friday, I know there's two prosecutors on this case. I understand that this prosecutor is going to be elsewhere, but in here, the main prosecutor who's prosecuting this case that will be available Friday for a hearing on this issue about my motion to...
I don't know if you heard that, but what Owens wants, so he just completely redirected away from the issue that they were talking about, which was whether or not the judge should view those videos. He just he interrupted and changed the subject. So that was a redirect. And he's going on about now, well, to have a hearing on this issue, Mr. J's not available Friday, but that other prosecutor is. So you see, he is prosecutor shopping. He's looking at that younger prosecutor thinking, I can play games with that one. I think that's my opinion. I think that's what he's doing.
I'm handling the motion to suppress issue.
Okay, that answers that question. I am here at your disposal, gentlemen, for when we might be able to set this motion for hearing.
Judge, if I may, we've been in contact with Dr. Brannon, and he is available.
Judge, if I may, and he has changed the subject again. He's not answering.
On October the 3rd at 3 p.m. I'm waiting on a location from him, but I believe that. Judge, that's Thursday at 3 p.m. That's the holiday. So I'm available that day. We just got to check with Dr. Boone about which location, whether Orlando or South Florida, where his office is.
So Owens is humming and hawing and just saying a lot of words that are unnecessary, talking about scheduling, ignoring what was asked, and is saying now that the doctor that he was just going to get him up here. Well, we'll see if he's available at maybe here or in South Florida after he's been told that the state can't go down there. So gosh, he's like a more sophisticated Sarah. He just hears what he just goes with what he wants, regardless of what everybody told him already.
He's not willing.
Mr. Owens, hang on, please.
He's not willing to do it up here, then we'll need to coordinate another time during the week.
Okay. 3 p.m. is not going to work based on the state's schedule and what they have to take care of on Friday.
Okay, I'll try to get him up here for that date and time, October the 3rd at 3 p.m.
Are you stipulating? Are you stipulating then, Mr. Owens, to having Mr. Brannon appear in person?
Wasn't that awesome? So Owen says, yeah, I'll try and get him up here for that date and time. And what he's doing is he's playing fast and loose because he's saying, I'll try. Right? And there's going to be some reason why he couldn't. There's going to be, just like there's, some reason that's in the mist somewhere why he couldn't give the prosecution the expert's CV or any number of other things that are going on here. But I'll try. And the judge, I love this judge, just comes right out. Oh, yeah? Are you stipulating? Is that what you're saying to the court? Like, come on. He's not giving a definitive answer, and Kranick's not having it. And it's wonderful.
Person for the October 3rd at 3 p.m. deposition here in Orlando?
I can't stipulate without talking to the doctor first, but I'm going to make every attempt to get him up here. But I'll let the court know, hopefully this afternoon, and the state know this afternoon.
So, well, actually, I can't stipulate because I need to actually talk to the guy, but I'm going to try. Well, that's not good enough. The court needs to know, pal. They need to know. So he's going to let the court and the state know later. Fast and loose.
Okay, all right. Getting back to the September 24th motion to suppress. State, how can we tee this thing up for hearing in time?
I did it again with the mic.
Okay, so that's a 3 p.m. ETA here.
Yes, sir.
Okay, got it.
Judge, my only concern is I know the two homicide detectives, I anticipate the state being able to have them available whatever day, but I do want the custodian of the records to bring from the sheriff's department, so I have to subpoena.
Okay. He's saying, Owens is saying, well, I understand that the state can have the detectives, the two homicide detectives, available any day, but Owens also wants the custodian of the records.
To bring the policy and procedures and the Miranda card
And he wants the custodian of the records to bring the policy and procedures and the Miranda card. What the crap? Has he not heard anything that the judge said? Dude, the policy doesn't matter. The law matters. The Miranda card doesn't matter. The Constitution matters. And he's just going to carry on down this road anyway. He's just going to do whatever the heck he wants anyway. This is so flippin' irritating. We are going to go through a couple of weeks of this guy. Honestly, we're going to need some sort of a game or comic relief or something. I don't know.
I'll advise the ASA and the defense in the trial that's set for Monday that we're going to have a hard break at 3 o'clock on Wednesday.
So the judge has a trial and somebody else's trial, and they have a right to a fair trial and they have a right to a speedy trial as well. But that person's trial is going to be interrupted to accommodate Sarah Boone. Just more and more and more.
If we have to work a little bit after 5 o'clock, I will let my court staff know that we may have to work a little bit later that evening.
And so now all the staff are going to maybe have to work late as well. Now, if you're the staff, and it's not just the court staff, it's security staff, it's corrections, so many people have to put in so much work and effort to accommodate her. And I am fine with accommodating defendants, making sure that they have dignity, making sure that they have a fair trial. That's great. But she, and now Owens, has people twisting themselves into a pretzel. I mean, imagine how would you feel if that was you having to work late for this woman, and I don't know, maybe it was your kid's birthday that night or something. I mean, she just gets so much.
In order to make that hearing happen, State, are you going to be able to subpoena your witnesses in time to get them here?
They will come.
All right. Defense is Wednesday at 3 p.m. acceptable. Mr. Owens?
Yeah, I'm here, Judge. I'm sorry.
Wednesday, October 2 at 3 p.m. for a hearing on the motion to suppress.
Judge, I'll work on getting my subpoena out today for the motion to suppress Wednesday, October the 2nd at 3 p.m. Eastern Standard Time.
Correct. At that point in time, we'll also address the motion that was filed at 1:13 this afternoon regarding clothing, etc., for Ms. Boone. I conferred again this morning, Mr. Owens, with Barry Click, the Public Defender's Office. She has not heard from you yet. Are you going to be relying on the Public Defender's Office to provide clothing? They are still ready, willing, and able to do so.
No, Judge, we were going to provide clothing.
Look at the look on her face. Look at the smirk. She's the flippin' queen. She is not going to have to depend on the public defender because she's going to get professional hair and makeup, or so she thinks. And the defense is coming to the jail to measure her. I mean, crikey, I don't measure myself to buy like just whatever off the rack, whatever size. And she knows it. What other defendant gets treated like this? And she is loving it. Loving it. You know what? If she is convicted, I hope everybody just flippin' ignores her. You can be Queen Sarah Boone for now. But you know what? George Torres's family is going to remember him forever, and everybody knows what you did.
Okay.
We wanted to get out there one day, early, Tuesday probably, to take measurements from her.
That's something you're going to have to address with the jail.
Okay.
I know I saw your motion. I don't even know if the state's had the opportunity to review it yet.
I have. I believe the shackles portion of the motion has been a ship that has come through here and sailed.
Not sure if you heard that. The prosecutor is saying, yep, we saw the motion about the hair and makeup. But, you know, the stuff about the shackles, that's a ship that's come through here and sailed. This issue has already been dealt with. And we were talking earlier, the clothing issue was dealt with too. She can have clothes. She can have access to makeup. She can fix her hair if she wants for the jury. But you see, this Owens and Sarah, they want it for not just the court hearings or the court hearing in front of the trial. They want it ahead of time so she can look good on camera.
And I believe all the clothing issues have been addressed by the court. The only thing that seemed to be new was the hair and makeup, and I did not see any authority cited that specifically said that was permissible. But we don't really have a dog in the fight. If court admin and security staff, however it works, is going to permit this to perhaps, as far as I know, be the first person to ever have this courthouse, that's between them.
The prosecutor said, if this happens, I believe it'll be the first person who's ever been granted that in this courthouse. There's a difference between being able to present yourself with dignity and, you know, trying to look your best. And you do want to look your best for the jury. And a jury seeing somebody in shackles and prison uniform, it does affect their perception, even if they're not consciously thinking about it. It does impact perception. But Owens wants more than that. And how much stinking work is that for everybody else? Do you know what it takes to transport prisoners from the jail to the court, and you're holding them there and then transfer them back? It's a lot, and the world doesn't revolve around Sarah.
There just appears to be a lot of discovery that is still outstanding, and that discovery includes medical records from several different locations, and things, those specifically, and perhaps other things that are probably pertinent to all three of the experts, the two defense and the state's expert on battered spouse syndrome. So I don't know how we want to handle that, because if this information finally does come in, and again, I believe the court has already accepted the state's arguments that once jeopardy has attached, then it's too late. But there comes a point in time where it's too late for us to get this new information to all three experts.
Judge.
Okay. They're talking about reciprocal discovery. Owens, the defense is not giving the prosecution the things that they promised, that the things that the defense is going to rely on, and the prosecution needs that. And this all should have been done by now, but Owens has been granted extensions. And as the prosecutor says, once jeopardy is attached, it's too late. And I believe the judge actually agreed with that concept in an earlier hearing, if I'm remembering correctly. I cannot help but wonder, strongly suspect, and this is my opinion, that these delays in getting that information to the prosecution is intentional. It's going to be hard for them. They're just going to be buried in work at the last minute. And when you're dealing with, and I'm going to use salesmen, but you know what? Predators do this. If you're talking to, whether you're dating someone or you're just meeting somebody at a party or in a bar on the street, they will talk fast and use a lot of words and sound like they're really nice. Like, yeah, I'm going to try. Hey, I'm going to do my bit. No worry, but I'm not promising anything, right? And just, yeah. Talk. And then spring something on you and require a very speedy response from you. And for some people in that situation, it's easier to capitulate, or you're sitting there thinking, what is happening? Right? I can't process it all because you're just being bombarded with all this information, and now you're required to respond. And this feels like that kind of a game. But I don't think the prosecution is that dumb. But boy, this behavior sure is practiced.
We'll call today to see where if the medical records are en route. We'll get the state an answer today, one way or the other.
Okay. Get the state an answer today, one way or the other. But if it's Friday next week and you get them, that could be problematic. Are there any other matters with regard to trial that we need to address starting on October 7? Jury selection is going to be here in 12 Alpha.
Yeah. So there was this whole long section that I cut out, and it was just the judge laying out, like, bit by bit, how they're going to do jury selection and how they're going to have 50 people in and blah, 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 all about that protocol.
So any questions with regard to that protocol?
No, sir.
Okay. All right. Anything else that we need to address, state, from your side of the ledger?
Just that based on the battered spouse syndrome evidence, we are, as well as the defense, working hard to get everything in rebuttal put together for that. I believe they have listed all the patrol deputies for the prior interactions that the defendant and the victim.
All the patrol deputies for prior interactions. Wow. Well, I hope then that the prosecution actually looks at all those body cam videos, and I hope they catch, because it was hard to catch when Sarah said, was it put the fear of the police into him? Basically, she was using the police as a tool, as opposed to using them for safety and justice. I hope whoever views that body cam video catches that. So, and all these deputies now. So this witness list just keeps getting bigger and bigger and bigger. This trial just seems like it's going to be forever.
Victim had in this case, we're going to be listing those as well. So I don't think that would constitute any surprise or great shock. But other than that, I think that's all the state has.
Okay. Address from your side of the ledger, Mr. Owens.
Just some discovery issues, Judge, but I think we need to deal directly with the state on those.
And discovery issues, what are you referring to specifically, just so that I'm clear?
That was good on Kranick's part, because now we know Owens is fast and loose, and he's, oh, just some discovery issues. What discovery issues on the eve of trial? That's significant. And you know what? Discovery issues on the eve of trial is an appeal issue, right? So, and then Owens can say, well, I put it on the record. I said there were discovery issues. And Kranick isn't going to let that slide. He caught that, and he's saying, oh, yeah? Specifically, what is it?
Well, there's a public surveillance video from Publix that we cannot get to play. We received it from the state, but we requested new videos or a specific program, but it will not play for us.
They're talking about the Publix video that the state gave to Sarah, and he's saying that they can't get it to play. So that is the video of somebody buying alcohol the night in question.
I assumed that Boone and George Torres were going to Publix the first time, and there was a second time that just George Torres went. So
This is significant information, and this is something I had not heard before. And that is so on the Publix video, the first time George Torres and Sarah Boone went in together. In her statement to police, she said he went by himself, and they had a bottle of wine, and that they had a little bit left and another bottle that was left over from another time, right? Well, turns out, according to even the defense, this video apparently is going to show Sarah and George going to Publix together on that day, and then George going alone. So there were 2 trips to get alcohol, not one. So when she slipped up and she said we had a bottle of wine, the bottles, plural, are in the trash. And then she tried to sort of recover later and it kind of explain away that second bottle. Well, now we know there were 2 trips to Publix.
we're trying to get that. We probably need a better address from that. So just some stuff that the state and I can get together and try to resolve.
Okay. All right. Anything else, State?
No, you're not.
All right, Mr. Owens, anything else?
I don't believe so, Judge. We're going to do our best this week to get all this resolved and be ready for trial October 7th.
Okay. We will see you next week. Mr.
And that was essentially it. And I am going to look at the chat. Hello, Helen B. Non-functioning alcoholics never have leftover alcohol. Somebody in the chat is saying, yeah. Michelle says they have receipts from 2 bought that day. Yes, I knew they had receipts, but I don't know if I was really clued into the fact that they were both on the same day. And Sarah had said that George went. And again, that's just another example of Sarah not taking responsibility. Well, George went and got it because, she can't drink. J Soul says she was drinking vodka that day also. I don't know if she was or not. Hello, Angel Baby. Nice to see the crew here. Okay, does anyone have questions or comments about the hearing? So we are going to cover this hearing on Wednesday. Jean is saying Sarah told Melissa, the apartment manager, to put the fear of eviction in him too. Yeah. I think to her, people are objects. I mean, that's such a feature of narcissism. If Dr. Barry is still in the chat, Maybe she can chime in on that. It's just such a feature of narcissism that other people are just their objects or tools. So she'll use the apartment manager, she'll use the criminal justice system, she'll use the probation officer, and she'll use the victim until she doesn't want to play with them anymore. The best Mama Bear, are they asking the state to pay for her hair and makeup? I don't, that's a good question. I don't think that's really what they're asking. If somebody knows that for sure, let me know. Aaron Double says that Dr. Pepper is significant. Yes, it is. Vodka pours right in. She was extra thirsty that morning. Yeah, that's a possibility. That's a possibility for sure. And she had it out on the counter already. What size of the bottles of wine? 750 ml or 1.5 liter? Jean, are you Canadian or British? Because I don't think they are in milliliters or liters in the U.S. But I do get your point. I don't know. Sarah gives me Jodi Arias vibes. Somebody's saying. Angel Baby saying, didn't Brian say Sarah was trying to make a drink prior to calling 911? I think so. And I think he said she was out before she called 911. She was outside having a smoke. And then when she was calling 911, she claimed to be doing CPR. I mean, she's not out of breath. You can hear the phone's not on the floor or something away from her. I don't know how you do CPR and talk on the phone like that. And then when the first responders get there, which happens while she's on the phone with 911, she tells them she's got a smoke burning on the back porch. I think she was out smoking on the back porch, pretending to count like doing CPR. Somebody said they looked at, Kranick is allowing the defense to say battered spouse in the trial. That, I did a video on that. That order came, that was a written order. So yes, they are allowed to say it in opening statements and throughout the trial. Could Owens constantly saying he's doing what Sarah asked be used against her if she wants to appeal poor representation? Against her? I don't think so. Captain Katie, yes, and went to smoke, yes. Angel Baby saying thank you, Trial TV Live, yes. It's always nice when creators are willing to help each other. I appreciate that. Lozarath says, I did CPR on my husband when he had a cardiac arrest. Oh, how terrifying. There's no way in hell she was doing CPR on that call. Oh, Hubs survived. Oh, I'm so glad. Sarah lied to Chelsea about George being the only one that went to Publix that day. Exactly. But that's what she does, right? She paints herself one way and everybody else has the flaws, not her. Is it possible for her behavior in jail to come up during trial? It would have to be relevant. It would have to be somehow relevant. So, I don't know how you do that. Paige, how do you stay so patient with the bad audio? Oh, I don't know. I really want to hear what's going on, I think. Rochelle says she's definitely borderline with narcissistic traits. I'm not qualified to say that. I mean, that sounds right to me, but I don't have the qualifications to make any kind of diagnosis. Okay. Did I get all the questions answered? Oh, I saw someone earlier in the chat. I think might have been Jerome saying TikTok, TikTok. Yeah. She didn't want this to go to trial, and it's happening, baby. Captain Katie, she lies about everything. Yes. And you know those people who lie by omission? I mean, their intention is to deceive, right? So it's still an untruth. She does a lot of that. She does a lot of hiding time. Jean says there's a witness who saw George at Publix with no injuries on him the day he died. That is significant. Linda says, I really hope when she's found guilty and sentenced that the judge puts in a ruling that she cannot profit from him. Yes. She's promised to own something. Why else would he be doing this? I don't know why he's doing this. But boy, he is really going all out for her, isn't he? Brat X, they always give themselves away. Well, you hope that they do it in time before there's too much damage, right? So the observation station, October 7th, is the trial. Let me double check. Yes. And on Wednesday, October 2nd, is the hearing on the motion to suppress. And I really, really want to hear that. So if it's available, I will stream it live. But you never know. They tell you it's going to be available and live streamed, and then it isn't, and then sometimes it is. I will set it up. I will be prepared to stream it live. But in any case, I'm definitely going to cover that. I've been practicing live streaming. I've got new equipment. I've done all this stuff just so I could cover this trial for you guys. All right, guys. I am going to go. I haven't eaten yet. And Watson needs some attention. Okay? Thank you very much for joining me, especially those who joined me twice today. Trust your gut. I'll see you in the comments.